propose that we now go into public session. Is that agreed?
Agreed.
The meeting today has been convened to consider the Cervical Check Tribunal Bill 2019. The purpose of the bill is to provide for the establishment of an independent statutory tribunal to deal with claims related to the cervical check screening programme process. I would like to welcome the Minister and his officials to the meeting this morning, and we will now go straight to the bill, of which there are 40 sections. The question is that Section 1 stand part of the bill. Is that agreed? In relation to Section 2, there were 4 amendments. In 1 to 3 inclusive are related. 2 is a physical alternative of 1, and 1 to 3 inclusive will be discussed together. Minister, thank you.
Thank you, Mr. Chairman, and thank you for convening this meeting today. The first amendment is an amendment from myself, and this is an amendment to ensure that women who had opted to participate in the OIRCOG review but whose slides had not been located currently by the laboratories in time and deadline for the OIRCOG review have the opportunity to access the tribunal. I think this is a sensible and prudent amendment to put forward. In relation to Amendments 2 and Amendments 3 from Deputies Donnelly and Deputy Kelly, I very much understand what the deputies are trying to achieve here, but what I have yet to find is a way of achieving it. And perhaps I would imagine this is something that we may need to continue to discuss and engage on further between now and report stage. I suppose I would make the point, Chairman, that we originally all wanted to establish an alternative process to court for the 221+ group. We asked a very eminent judge, Judge Charles Meenan, to do some work in terms of designing that pathway, and he came back with the substance of what is the legislation before us effectively. On top of that, we decided that the sensible thing to do was to include those who had also opted to participate in the Royal College of Obstetricians and Gynaecologists review from the UK. I suppose what these amendments, for understandable reasons from Deputy Donnelly and Deputy Kelly, are asking is that we broaden it beyond that to other categories of women, and most particularly in the case of Deputy Donnelly's, he's asking understandably for women who perhaps said they didn't wish to participate in OIRCOG, but now may wish to access the tribunal, that we would find a mechanism for that to happen. I suppose the challenge that I truthfully have is that the OIRCOG review is obviously independent in the first instance. The deadline for participation set by the independent OIRCOG has now passed. I think from my memory the deadline was the 7th of June, but certainly the deadline was in June. And it's obviously due to report and is very eagerly awaited by a lot of women and their families, in a very sensitive matter as well. So I've yet to find another mechanism whereby those who have not had an audit, be it by OIRCOG or the cervical check audit, could be audited. I think we'd all understand that if you were to even find another process, that process would have to be, to a quality and a standards that we'd all be satisfied with. And my fear was that would delay the passage of this much needed legislation, which I'd like to get passed by the summer recess so the tribunal could begin its work in the autumn as well. Now, I would make the point that I do see this tribunal as a potential, as does Judge Meenan in his report, as a potential template for perhaps looking at clinical negligence issues into the future. And there is a body of work by Judge Meenan underway on tort reform in general. So I don't imagine this is the last time we'll be legislating in this area, and perhaps it's something that we'll be able to return to in the future, but I can't currently find a way to broaden the scope that would be acceptable.
Thanks, Chair. Thank you, Minister. So to your amendment, Minister, I'm certainly happy with including those women in that. Amendment 2, Chair, I might just lay out the purpose of Amendment 2. So the women who will be eligible to participate in the tribunal in the first instance are the 221+ group. There was that group, and then there's a second group who were the 2,000 or so women who were on the National Cancer Registry as having been diagnosed with cervical cancer, but cervical check hadn't been told. And those roughly 2,000 women, Minister, as you've said, they were offered an audit carried out by the Royal College of Obs and Gynae in the UK. and about half of them said yes. And that's about 1,000 women. And so those 1,000 women, under the bill as it stands, have access to the tribunal. So the question then is, what about the other 1,000 women who said no? And the women who said no without knowing that in saying no, they were losing access to the tribunal. And we don't know how many of them, if they were told, look, there's a tribunal coming, and in order to have access to the tribunal, actually, you need to participate in the review. We don't know how many of the 1,000 who said no would have said yes. But it's reasonable to think that it's more than zero. So I would imagine that there is some number of those 1,000 women who, if they were approached now and told, here, look, the tribunal is in place, it is limited to a set of women, and in order for you to have access to the tribunal, you need to participate in the Oireachtas review. That's the deal, because they're the recognised independent body who will be able to bring back evidence that the tribunal can use. Inevitably, there is a number of those women who would say, yes, actually, now that I know this, I would like to participate. And so that really is what the amendment seeks to do. Now, I take the Minister's point that the Oireachtas review is an independent review. The deadline for involvement that has passed. Okay. And so what I would very much like is for the Minister, for his officials, to find a way that this other group of women can be offered participation in a review, be it by Oireachtas or be it by cervical check here in Ireland, or there might be the French might have an authority, the Germans might, whoever. They might have an expert group that would say, yeah. So if we assume that, or actually, Minister, the 50% said yes. So let's assume of the other 1,000 women that, who knows, 1 in 5 say yes, given this new knowledge about the tribunal. So I guess the question is there another body out there that can handle probably a few hundred reviews in reasonably short time? It would need to be, obviously, of the highest quality, just like Oireachtas, fully independent. And let's make sure that the women are made the offer. And so maybe it's the French equivalent of Oireachtas, or the German one, or whatever international group is deemed appropriate. So I'll move the motion, but the amendment. I'm happy to move it and withdraw it. But could I ask if you're willing to ask the department if you agree with the principle? I guess question one: do you accept that actually this 1,000 women who said no, if it is possible to find a way for them to go through an Oireachtas type review, they should be made the offer because they said no in the absence of knowing about the tribunal? Do you agree with the principle? And if you do agree with the principle, will you commit to tasking the department essentially with trying to find a mechanism to let that happen?
So, Kelly.
It's just responding in one way because it's we'd be doubling it up otherwise. My amendment is very similar to Stephen's. It's more or less doing the same thing, just written in a different way. Firstly, I welcome the first amendment put down by Tara. I think that's a very good amendment. It's something that has been suggested, I know, by myself and others, so I'm glad that you've taken that on board. I remember the day, Minister, when you walked into the Dáil after a good bit of probing and found out about the extra 1,000 women, or more actually, sorry, from the whole disconnection between cervical check records and the cancer registry records, which is something we've been through ad nausea in here in relation to how, never God, that ever happened. And really, I suppose, this bill, as regards the actual women who can participate, is too narrow. Now, I said at second stage that I have concerns about this legislation. I'm not sure if I'd recommend somebody use this tribunal as the way it's currently constituted, and I say that with a lot of knowledge of and discussion with patient representatives, because at this moment in time they certainly wouldn't necessarily advocate it. In principle, we all want this tribunal to work. In principle, we all want it to be effective. But in doing so, we have to make sure that, one, women and their families see it as the best route, and two, it's as inclusive as possible. There's a cohort of women here, and that's the reason why my amendment changes in page 6, lines 34 and 5, to delete as part of the retrospective cervical check cytology clinical audit and substitute whether as part of the retrospective clerical check cytology clinical audit or otherwise. The issue here is there was a cohort of women, as the previous speaker has said, who are outside of this now, and were almost blindsided by the fact that they could have been advised, for many different reasons, not to go through the ORCOG review. And because they didn't go through it, they don't have access now. Now, that can't happen. So we've got to find a solution. They have to have the option. I don't believe that what you said, I know you said it for the right reasons, but I don't believe that this tribunal has to be held up because of this. I understand, and I'd like you to clarify, will this tribunal be held up anyway because of the appeal of the Ruth Morrissey judgment, which I suppose I've spoken quite at length at as regards disagreeing with. But in that scenario, obviously there is a window here to deal with this issue, because the likelihood is that that judgment isn't going to take place until the autumn. So we can pass this legislation, but we can do so with an amendment of either myself or Stephen. I'm not going to get hung up on the amendment, or something you propose yourself, which we would agree with. I presume other speaker, if you came up with it yourself. But in the meantime, there would have to be a mechanism found in the vacuum to deal with these women who are outside the process. I don't think we have an option here. This has to happen. It's just a mechanism by which we can put it into the bill, and then separately, how can it be done outside? Women are written to, given the opportunity. Obviously, there would have to be some form of deadline. We have a vacuum now, obviously, with the Ruth Morrissey judgment as well. And let's see what amount of women we're talking about and deal with it. Thank you.
Thank you, Deputy Kelly. Deputy O'Connell.
Yeah, just to see if we find a solution here. So this is the group of women that chose initially from the cancer registry list. Half of them just decided not to engage. Do we have any research as to why that decision was made? I mean, I'm just trying to be helpful here. There must have been some reason why they didn't engage with the ORCOG process. Now, I really don't understand, and maybe I missed something, why you'd go to another jurisdiction if you did, if you got, we'll say 1 in 5, 200 of the 1,000. Why would you go to another jurisdiction? Because it would seem that that would create an inequality again in terms of standards. But, I mean, if we think we can get to the core as to why those women didn't engage in the first place, we might find out where we should go. But I do agree that we don't want anyone to have slipped through the net as such and not be able to engage. But if someone could advise us as to what the reason why, that might help us inform where we're going. Because at the end of the day, we're trying to sort out the people in the least adversarial way and without them jumping through too many hoops. Thank you.
Chairman, I think there's been a very constructive engagement. I just want to start with Deputy O'Connell's point, because it's the one I was going to make. We just need to be very careful as a collective here that we're not second-guessing or endeavouring to second-guess why women chose not to engage with the ORCOG process. Let's remember the women on the cancer registry. No one is endeavouring, no one's trying to do that. I'm not suggesting anyone is. But let's remember, for a lot of people, their cancer journey may have ended a number of years ago. They may now be in very good health, and they don't wish to have an independent review. They don't wish to go back, and that's their choice too. So the figure I have is 63% of women on the cancer registry, part of the ORCOG review, 63% consented. So that's the figure. It's not quite a 50-50 split. So 63% said yes. That means about 37% didn't say yes. And I think Deputy O'Connell's right. That's for a variety of reasons. Nobody chose to enter the ORCOG process as a passport to going to the tribunal, because nobody knew about the existence of the tribunal. Women chose to do it to have the option of having an independent external review of their screening history and a determination or not if there was discordance. Some women decided, yes, I'd like that. Some women said, you know what, I don't. So that's just one point worth making. And I don't have Deputy O'Connell, I don't think anybody has, but I think it's a valid point, the reasons why different women made different decisions. But I think on a human level we can guess them. Different people are at different stages in terms of their health and their well-being and their family life. But I do think you make a fair point. I really do think you make a fair point, because nobody wants to be unfair here to what I would guess is a relatively small number. Because if 63% have said yes, that leaves you with 37%. Of those 37%, no one in this room can tell me how many would like an independent review, why they'd change their mind now. So it'll only be a proportion of that. And then only of that proportion would it be people who have a discordance who'd be able to enter the tribunal. So remember, the access to the tribunal is based on a finding of discordance from either ORCOG or the retrospective cervical check audit. So I would imagine, not having done the maths here, I'd imagine it's actually a very small number, or certainly quite a small number. And therefore it actually heightens your argument, in my view, as to if it's a small number, why would we not try and deal with it? I can't deal with it here on the floor of the committee. I don't think you're asking me to do that. What I can say as a statement of fact is that the ORCOG review is closed, is independent, is closed. And I also would say, and I think we'd all agree on this, it's really important now that that's actually closed and gets onto reporting in the autumn, because there's an awful lot of women waiting for that, and no one is asking to do anything to delay that. So I'd respectfully suggest, Chair, that I would reflect and engage further with members of this committee between now and report stage. That's quite a short window, and we can see if there is a way of coming up with this either in this legislation or indeed a commitment to return with a proposal shortly in this regard. I do just need to make one point. You know, we need to be careful of scope, and when we're trying to be fair, we need to be careful we don't create other inequities along the line. So there'll be a woman today who'll go for a smear. There's no audit underway today because we have to come up with, as per the Scally recommendation, a new audit. So this tribunal can't be, and no one's asking for it to be, an ongoing process forever and more. The patient said they wanted it to be timely, time limited, scope limited. So we just have to be conscious that we're not trying to broaden this too much. I don't think anyone is trying to do that, because there's a broader piece about clinical negligence that I think is a bigger piece of legislative work for us to do. So I am happy to work with the deputies who put forward these amendments and other colleagues to see if there is a way we can find it. I do need to highlight, I don't think it's easily done, but I'm very willing to try and to ask my officials to do it and to report back to you, and if there is a way to at least update the Dáil at report stage on where I think we're at.
Thank you, Minister. So, Minister, are you going to move the amendment? Sorry, Deputy Donnelly.
When is report stage? Is it next week?
Expected to be next week, subject to passing this today.
So could I just ask that rather than us hearing the answer in the Dáil in report stage, could you come back, or the officials come back ahead of time?
Absolutely.
Because it sounds like we were all agreed with the principle, and it's about finding a mechanism.
It is, and I'm just yes, no problem. And I'm just flagging the finding of the mechanism. I think is tricky.
Yeah.
I'm not saying it's beyond us, it's tricky. What I don't want to do is mislead this committee into thinking that I could find it in a couple of days. It might take a little bit longer, but I can certainly, I think we know what we want. To do as a
find a mechanism,
find a way of providing assurance on the issue.
Look, I mean, I suppose the spirit in which this has been put forward, I agree. In fact, from all the analysis, I believe this would be a fairly small figure, right? However, there are some women who've been in touch with us and their families. There are others who actually don't know, right? And we need just a process to ensure they're gathered and put through another process. Maybe, I mean, it can be dealt with as part of the bill, but even if it's not, we'll take your bona fides if there's another mechanism by which it can be done. As long as it's dealt with, we're not going to die in the ditch on the actual amendments. As long as it's dealt with. We just want to make sure it's dealt with.
I think that's fair, I appreciate that.
Okay.
So, Minister, are you moving the amendment 1?
I move Amendment 1, Chair.
So the question is that this amendment be made. Is that agreed? Thank you. Amendment 2 cannot be moved.
Finish the toilet.
Okay, because it's an alternative.
Sorry, it's an alternative.
It's not. They're talking about two different groups of women. They're not alternatives to each other.
Okay, are you withdrawing?
Are you,
Amendment 1 from the Minister is about cases where they can't find the slides. Amendment 2 is about women who have chosen not to engage in ORCOG.
are you moving amendment?
I'll move it and withdraw it, yeah.
Move and withdraw.
Yeah.
Thank you. And amendment 3, thank you. The question is that section 2 as amended stand part of the bill. Is that agreed?
Agreed.
The question is that section 3 stand part of the bill. Is that agreed? That section 4 stand part of the bill. Is that agreed?
Agreed.
That section 5 stand part of the bill. Is that agreed? That section 6 stand part of the bill. Is that agreed?
Agreed.
That section 7 stand part of the
You're
bill.
fine.
Is that agreed?
On record.
That section 8 stand part of the bill. Is that agreed? That section 9 stand part of the bill. Is that agreed? That section 10 stand part of the bill. Is that agreed?
Agreed.
In relation to section 11, there is one amendment in the name of Deputy Kelly.
Thank you, Chair. I made the officials and the Minister aware of this. And this isn't actually, it's just I've read this so many times and it causes confusion. So this is a drafting issue, and I'll just point the colleagues to it. It's in section 11.1a. And I would just seek your advice on this, because if you read it, subject to section 12 and subsection 2, an appropriation person may in the prescribed form and manner make a claim for compensation to tribunal seeking damages for negligence, breach of duty, breach of statutory duty or breach of contract arising from any act or omission concerning cervical check. Or, how stands that or? Because for me, you can read on and it can have different interpretations.
Yeah.
So you were to look at this, I think.
Yeah, it's this chair is a.
You could look at this twice. And
Yeah, this
see
is
totally differently.
the eagle eye of Deputy Kelly and his legislative scrutiny, who may well have spotted a drafting error here, but I don't believe it is a drafting error, but I've sought the Attorney General's advice. We read the or as an and or. And my
It doesn't say that, though.
in-house legal advice suggests that that's the meaning of the word. But if there's a genuine drafting error here, because we all know what it's meant, to mean, so there may be a drafting issue here. I've sought the AG's advice on the impact of the deletion, and I'll come back
It's just
on
that-
report stage. You may be right, but we just need
It's
to
just
get
that
clarity.
and/or
Yeah, is the difference?
is A&D/or.
Yeah.
This is just
the
or.
word or, exactly. So let me await the AG's advice. The
Okay,
meaning is
no
and or.
problem.
The meaning is
Grand.
and or, and
Love
if
it.
there's a need to fix it, we'll do that.
Perfect, no problem.
Are you moving that amendment?
Move and
withdraw.
withdraw. Move and withdraw.
The question then is that section 11 stand part of the bill. Is that agreed?
Agreed.
In relation to section 12, there are two amendments, Amendment 8 and Amendment 9. Amendment 8 in the name of Breed Smith and Amendment 9 in the name of Alan Kelly. 8 and 9 are related and will be discussed together. Deputy Smith. Deputy
Sorry.
Smith. Yep.
Um,
Amendment 8.
I think the reason for this is that the bill wants to put a limit on women accessing the tribunal to 6 months when after they find out about their slides, or within 9 months of the establishment of the tribunal. But we want to ensure that their rights are no different to others. Can the Minister explain why these dates were chosen?
Yep, Minister. Thank you.
Shall I take the two together?
Sorry, Deputy Kelly.
I've raised this issue. There's an inconsistency here in the legislation versus similar types of legislation. So the Personal Injuries Assessment Board, they add on 6 months to do so for obvious reasons, so that people don't end up outside the statute of limitation. And it's done with good reason. Because at the time of notification, if somebody misses a notification, etc., they could accidentally end up outside the time period. So it's just good practice that they add on 6 months, and that has been validated and has been pushed through in other legislation in the past. So genuinely asking that this legislation would reflect that as well, as per the PIB Act.
Okay. So if I can just respond to the two Cahirlock, in relation to Deputy Smith's amendment, I see what the Deputy is trying to do. So the statute of limitations obviously continues to apply here in terms of access to the courts. So obviously it's the same statute of limitations for anybody else as for any other issue. So it's a 2 years from the cause of action. In relation to the tribunal, when we asked Judge Meenan to do his work, one of the things that came back from the report, and indeed from his engagement with patients and others, was that this should be timely and more efficient and more speedy than the court system. So we have tried to time limit this tribunal so that women can get answers quicker, and we've picked a figure of 9 months. And I'm satisfied that that's appropriate. It's different to Deputy Kelly's point, and I think Deputy Kelly has a point here that I do need to return to at report stage. What the Deputy is suggesting is that if the tribunal says we can't help you, which can happen for a variety of reasons. So if the tribunal says, after considering the case, we don't believe we can take the case, what the Deputy is suggesting is that there should be a period of time, extra time if you like, in addition to the statute of limitations, to allow a woman to talk to her lawyer, talk to her family, consider the issue. I think that's right. We might agree on this. I think the 6 months might be too long for different reasons, and I need to engage with colleagues on that. But I am committing today to bringing my own amendment. Of course, Deputy Kelly can resubmit his amendment around 6 months, but I'm committed to bringing my own amendment at report stage that will provide for an additional period of time. I think it's likely to be less than 6 months, but I haven't landed on a figure yet.
Thanks, Minister. I'm glad you've reflected on my amendment. I think it's common sense because if determination has been made, they need a period of time to be able to decide what they're going to do next. I would just, and I know you're going to reflect on it, but I would just say that from a consistency point of view, with other legislation of similar categories, it is 6 months. So I don't see a reason why it would go outside that. But I'm glad you're taking the amendment in the spirit, and we'll see what you draft. And on that basis, I'll move and withdraw my
Thank
amendment.
you. Deputy Smith? Move and withdraw. The question is that Section 12 then stand part of the bill. Is that agreed? In relation to Section 13, that Section 13 stands part of the bill. Is that agreed?
Agreed.
Thank you. That Section 14 stand part of the bill. Is that agreed?
Agreed.
That Section 15 stand part of the bill. Is that agreed? That Section... Deputy Smith is opposing Section 16?
Yes.
Deputy Smith?
Well, the argument here is that it shouldn't have any impact on the award from the tribunal, which would be maybe judging from a different category of injuries, and therefore why should the ex gratia be minus?
Yes, so I think I understand I understand Deputy Smith's point. I suppose there's a balance here. Obviously, if we've already made a payment for non-disclosure through the ex gratia scheme, and obviously we've fixed that payment as a set payment of 20,000. When I say we, an independent assessment panel has done that at 20,000, and those payments will start issuing in the coming weeks. What we're saying is that the tribunal shall take into account the payment of an ex gratia scheme. Now, we've worded that in such loose language, if I may call it that, for good reasons, because what we're not saying is that the tribunal must deduct it. We're saying it shall take it into account, because somebody might want to go to the tribunal, and indeed I've spoken to some patient advocates on this. Somebody might want to go to the tribunal and argue, yeah, I got the ex gratia payment, but God, the manner of my non-disclosure was particularly horrific or had a particular impact, and I want to argue that in a tribunal, or indeed I want to argue that in court. So we're only saying shall be taken into account. We're not saying the judge must deduct the €20,000. But we do need to be cognizant of the fact that we have made a decision already to pay 20,000 for non-disclosure. But that does not take away from somebody's entitlement when they go to a tribunal or indeed go to court to argue that they should be entitled to a quantum larger than that, such was the impact of the non-disclosure on them. So I haven't said must be taken in, it must be, will be, shall be. I've worded it in such a way that gives the judge and the tribunal that discretion.
Okay, move and withdraw.
Thank you, Deputy Smith. So the question is that Section 16 stand part of the bill? In relation to section 17, there are three amendments, 11, 12 and 14. 11 and 14 are related and will be discussed together. The first amendment is in the name of Deputy Alan Kelly.
Thank you, Chair. This is an important issue, Minister. My amendment relates to the fear that some women who will be diagnosed and are treated, but then they face the risk of it actually recurring. And obviously women with cancer, recurrence unfortunately happens, and it happens within a short period of time, and statistically in many cases. 5 years, the first 5 years is the biggest risk. It can happen later, but that's less common. So if a woman takes her case to the courts, she knows there will be a finality to the decision, and if she suffers a reoccurrence later on, that's it. That's the court system. She won't be compensated. That's unavoidable. But it's not unavoidable in a tribunal, and we have precedent for it. So we have a statutory provision being made for a new type of form, i.e. the tribunal, one operating to the practice and procedure of the High Court, yet free to make its own rules. So it provides for the cross-examining of witnesses and a whole range of other things. But why then can it not provide, as the Hep C tribunal, for all awards to be made as an interim award? So that if a reoccurrence happens, that the woman can return. Because unfortunately, in this scenario, there are going to be those cases, and they will be locked out of going back and seeking damages, whereby in some cases, unfortunately, the health outcomes may have deteriorated significantly. Thank you.
Thank you, Deputy Kelly.
Can I address the same one?
Yes, Deputy Smith.
In amendment number 14. I think this is really important because anybody familiar with anybody who suffered from cancer, the return of the cancer can be absolutely much more distressing and much more dangerous than the original case. And if we don't allow for that, then I think that's really punitive. And there is a likelihood in certain cases that it will return later on. And what do women do if they find themselves in those circumstances without the means, the financial means, the physical means, the support mechanisms around them to deal with the stress, which is double, treble what they originally felt? And I think we do have to allow them to return to the tribunal to receive the protection and the support of the tribunal and therefore of the state. I think to do otherwise would be really punitive. And as Deputy Kelly has said, it was allowed for in the Hep C case, and all you have to do is copy and paste what was allowed for there and insert it here, which is what we've done.
Deputy O'Connell.
Yeah, just briefly, maybe someone could give us advice on this. I would have thought it was complicated to link a representation of cancer later in life specifically to an incident 10 years previously. I'm just, like, where does the line get drawn? Otherwise the tribunal could go on for 100 years or whatever, maybe 60 years. So I think the Hep C is slightly different in terms of the infection and transmission is very much quantifiable and identifiable from the point of the infection of blood. I'm not an expert in this, but I have a small amount of information. So it would be very, very difficult to connect a cancer occurring 10 years after you have the all clear or whatever. Thank you.
Deputy Durkan.
Yeah, this could be a difficult situation, Mr. Chairman. On the one hand, it's readily recognisable that a person who has had cancer and has been diagnosed as having cancer and obviously cured of the difficulty, that it comes back subsequently in years at some later stage, and the extent to which you can identify it as a continuation of the previous condition. In the Hep C case, from my memory, and it's vague at this stage, a long time ago, everybody had the right to go to the tribunal first. If not satisfied with the tribunal, everybody had the right to go to court. There was some conflict arose because some advice was given to some of the patients that they shouldn't go to the tribunal, that they should go direct to court. And it caused a problem with the attempt there was to speed up the processing of the cases so that the people who were directly affected could have some recognition of their condition and some compensation for it. And remember that it was very similar in the sense that, you know, time was passing all the time, and there was a worry and a constant worry there. And it didn't work out exactly as was intended from memory as well, but it did resolve the most immediate problems in the sense that it couldn't have been stated that their case was ignored. The first part of it was dealt with in any event. The next part of it, in some cases, took on a longer life and was more difficult to resolve. So I understand what the case that's been made there, but it's just I think there is a difficulty in determining whether or not we're dealing with the same thing, a continuation of the same thing, or a new, totally different condition which may be cancer and lead to the same problems actually, but not directly linked. I'm not certain.
Thank you, Deputy Durkan.
Can I make one further
Yes,
point, Chair?
Deputy Smith.
It's just a simple point of if the intention is to get women to partake in the tribunal and to participate in it, but you're asking them to sign a waiver against any future claims that may be desirable from their point of view in the reoccurrence of the same cancer. We're not talking about, you know, they get cancer of the eye or the brain or something later on, they come back, but of the same cancer reoccurring, and you're asking them to sign a waiver. I think you're in danger of discouraging them to participate in this. I think that is blocking it, and you know, not being, obviously none of us here are doctors or scientists apart from yourself, I think, on these issues, but I think if just in practical terms, if we're trying to support and to acknowledge the failures of the system, of the state, of the cervical check in dealing with women's health, and we're acknowledging that in a way that's real, then asking them to sign a waiver in the case of their future health is, I think, very unreasonable. It's unreasonable, and it will deter women from participating.
Deputy Kelly.
Very quickly, look, the bona fides here are absolutely 100%. The amendments are more or less the same from both myself and Deputy Smith, because it's taken from the Hep C tribunal. This tribunal can set up its own rules and procedures. Okay, I appreciate what other deputies have said as regards linking and the difference between Hep C and cancer, etc. However, it's undeniable that there are linkages when it comes to recurrence of cancer. We all know that. We've all seen it inside here. So, I mean, from my perspective, this amendment is one I will be pushing, not today, but if it's not solved, I'd be very happy to have discussions with you as regards a joint agreed amendment. But I don't believe that this legislation can go through without dealing with this, because as Deputy Smith has said, this is a reason why, and one of the largest reasons why currently that women may not go through this tribunal, because it limits the tribunal in how it can bring about finality. They don't know what their future is in some cases. Unfortunately, that's the situation they're left in. So if you can't bring forward an amendment, I'll certainly be pushing mine at report stage. But I believe in the spirit of the legislation, the spirit in which you're dealing with this legislation, if you would reflect on it and bring forward an amendment. By the way, there can be some time period put on this. There could be some time period put on it as regards 5 years from whatever commencement, or 5 years from when each case was settled, or whatever. We can work on that. But not dealing with this isn't an option for me.
Minister.
So I think Deputy O'Connell hit the key point for me in relation to this.
That's twice today, no?
In fairness to it, I gave you credit the last time. She's very...
Probably made a key point for you.
Absolutely, she often does on these matters. She's well informed. But the key point was, in fairness to both Deputy Kelly and Deputy Smith, you both said very openly that this is a replica in terms of the amendments, or the intent of the amendments to the Hep C compensation tribunal. So my starting point in relation to this which I think we'd all acknowledge, is that this is obviously very different to Hep C. So in relation to Hep C, there was no adjudication required in relation to the medical facts of what happened. We as a state infected women with people with contaminated blood, and we as a state had a duty to mind them and care for them throughout their lives and to try and right that wrong. And as their needs and health needs changed, that tribunal continued to be able to make various orders and payments. So this is something we've never done before in the history of the state. It's an adjudicative tribunal. So the Hep C Compensation Tribunal was recognising that the actions of the state made these people ill. That's not the case in this regard. The case in this regard is people were let down due to, in the first instance, non-disclosure, and in some instances there'd be negligence, but not in all. Not in all. And I've heard both patient reps and their solicitors publicly acknowledge that fact, that not every case will be negligent. Some cases will be within the limitations of our screening. So in that sense, it is more complex. However, I get, and to use the phrase bona fides, fully get and accept Deputy Kelly and Deputy Smith's bona fides in relation to what you're endeavouring to do here, and it is an important issue. And I have already taken advice on it, and I'm happy to take more. And I think Deputy Kelly hit on something important here in relation to the rules and procedures of the tribunal, which I might touch on in a second. So the advice that I've already been given, the legal advice and the advice from the tribunal, is that the judge can and will take into consideration the medical evidence in relation to risk of recurrence, future health, future well-being. So the judge will not be, or the tribunal will not just be looking at the person today and the impact of them today. They will be able to hear from the medical evidence, and indeed will have their own experts, which is another difference to the High Court, that the judge will have her own experts, not just the experts for both sides in relation to future risk of recurrence, which I think is quite important as well. Deputy Kelly did say that there are rules and procedures set out for every tribunal, which basically says, look, these are the general kind of principles I'll be applying. No, I have to be very careful that I don't write them. The tribunal is obviously independent. But perhaps the rules and procedures is somewhere where this could actually be made very clear, that the risk of recurrence and the risks of future health is something that is considered and assessed by the tribunal when they make an award. Now, if you were to, Deputy Kelly qualified this in his last intervention in terms of talking about a time limit. If you were to take the amendments as read today, or indeed versions of the amendment, we would effectively be committing as an Oireachtas to the ongoing maintenance of a tribunal. If that's what the Oireachtas wants to do, that's very different to what we started out doing, because what we started out doing with the Meanin report was a time-limited, scope-limited, efficient way for women to get answers, to get justice, and where there is wrongdoing, to get payment. So we'd be moving into a very different space if we're talking about the ongoing maintenance of a tribunal, as the Hep C one has been maintained for many, many, many years. And just the final point I'd make, Chair, and it's a key point to make. People mightn't welcome me saying it, but it is true. This is a voluntary process. We need both the women and the labs to participate, and either side can decide, I don't wish to participate. And I think it'll be very different asking labs to participate in a process that will be ongoing forevermore. So I don't want to pass a piece of legislation that looks like I'm providing an alternative to the court to find out that it won't work. In reality, we didn't have that complication with the Hep C tribunal. It was just the state and its citizens. Here we obviously have different parties, including parties that are external to the state, and they have a choice as to whether they wish to participate. It's voluntary, and legally has to be. So to try to get both parties to participate is important too. So look, I'm happy to engage with both Deputy Smith and Deputy Kelly between now and report stage. I understand Deputy Kelly and Deputy Smith may well resubmit their amendment. I'd like to try and provide further information as to how I think this can be dealt with and can possibly be dealt by rules and procedures of the tribunal. But can I suggest we'd engage further between now and report stage, and obviously you've the right to resubmit your amendments.
Minister, Deputy Smith.
And I take the latter point about participation by all sides. That's obviously what we need to do. But what is being required here is for the woman to sign a waiver. And that's what we want to remove, is the requirement to sign a waiver. Because that waiver may indeed mean that, regardless of the 5 years mentioned by Deputy Kelly, but in 10 years or 15 years' time, if there's a reoccurrence of cervical cancer, that person has no redress for the negligence that she suffered through the cervical check, or can't even investigate it or take it to court. Now, you said at the opening, in your opening remarks in response to what we've just proposed, that this is quite different to the Hep C case because in the Hep C case, people were let down by the state. This is not the case here. Can you repeat that or enlarge on it, or just say it again? What you actually mean?
Because I'm sure you wouldn't. I'm sure you didn't intentionally. I definitely didn't say that. Let me be very clear.
You said a version of it. I just would like
a very different version. A very different version because words matter. As Minister for Health, I've been very clear from day one that women were let down by the state in relation to the non-disclosure of a retrospective audit where they were meant to be disclosed to and weren't. So to be very, very clear. Apologise for that. Many women, many families spent many hours with them. So don't in any way accidentally or otherwise misrepresent me in relation to that matter. What I have said is... You didn't, so thank you. And the record will show that's not what I said.
No, sorry, it wasn't about the non-disclosure. Yeah. It's about the whole package, the cervical check system.
Yeah, but it's just easier if we don't. You suggested there, accidentally or otherwise, that I said women weren't let down by the state. Women were absolutely let down by the state, 100%, in relation to the cervical check audit. Absolutely. And the facts of the Scally report are there for all to see and accepted. And my bona fides in relation to this are very clear and understood by people who are directly impacted by this, which is what's most important to me in this regard. What I've said is, and it's a statement of medical fact, that the infection of people in our country by contaminated blood by the state is very different to the limitations of screening, where in some cases there will be false positives and false negatives. This is all documented in the Scally report very clearly. Very clearly. You can bring in any medical expert you want here. False negatives, false positives. But in some cases there's negligence. And there's a difference, a very big difference, between a false negative and a negligence. And the reason this has to be an adjudicative tribunal rather than a compensatory tribunal is because somebody needs to establish and adjudicate whether there is negligence or a false negative. And that's the role of the judge, supported by experts. And the reason we're doing this as an alternative to court is, in Judge Meenan's report, he outlines 7 or 8 reasons as to how he believes this is, he doesn't use the word but I use it, a more compassionate or better approach than the court system. And he arrives at that point after meeting with many people, including Dr. Scally and patient representatives and others. It's not a perfect model. I don't think there is one, quite frankly, because of the complexities of this. So I'm not going to pretend it is. It's not a perfect model. But I do think it's a better model, or certainly an alternative to court. But what I don't believe is, I don't believe this is a replica of the Hep C issue. And I don't believe that the tribunal is, because it isn't legally. The Hep C tribunal was compensatory. This is adjudicative. It has to establish the fact, was there negligence or not. The Hep C tribunal never had to do that, Deputy Smith. It just had to decide how to compensate and look after people in the court. Okay,
thank you for that explanation. But if I may finish my point, I'm not trying to say that the Hep C is a direct copy of what happened here. But I think it is absolutely wrong, and you haven't been proven yet, as representative of the Department of Health for the state, you haven't been proved in the all clear, despite the Scally reports, that the actual arrangement between the Irish state and the labs in America was not at the heart of this problem. That hasn't been proven to be the case. And I think you're jumping the gun by saying that the state doesn't have a responsibility. In fact, your predecessor, when he was in opposition, James Riley, actually argued the opposite, that the arrangement of outsourcing between the Irish state and the labs in America was dodgy and could lead to real problems.
Dr. Scally, I believe, is before this committee tomorrow.
Just let me finish my point,
But
Minister.
you're misrepresenting the Scally report. And you know what?
No,
it's
Minister, let me finish my point. It's not fair to interrupt me. I didn't interrupt you.
Well, you did it's grossly irresponsible, Deputy Smith.
Sorry, Deputy. Let the Minister respond.
The Deputy is misrepresenting Dr. Gabriel Scally's reports. The Deputy is presenting herself as almost as a cytologist in pursuit of an ideological viewpoint on outsourcing, which she's perfectly entitled to hold. You're perfectly entitled to hold your ideological views in relation to outsourcing. You might even be right that it'd be better to do things in this country, but you're not right in suggesting, and you're now applying a new test that you haven't been proven that it didn't. I mean, that's a bizarre test. Dr. Scally found that despite the massive deficiencies, by the way, for which I wasn't in office for any of them, but let's park that, for the massive deficiencies that were found in relation to the screening programme in terms of its audit, procurement and governance, he did not find safety issues.
Can I finish my point?
And you'll have a chance to ask him tomorrow here.
Chairperson, may I finish my point?
Yes, Deputy.
My point is not to question the cytology or the science of the cytology. My point is to question what you said, that this is quite different to the Hep C insofar as the state is not responsible for the outcomes. And I think that we have to question that. And the jury, the dust isn't settled and the jury is still out on it. Dr. Scally has done some fine research and fine reports, but there's still a huge amount of question marks and there's still a huge amount of gaps left in it. And no matter how many times you keep telling me that I'm doing this for ideological reasons, I'm also being logical about it. And there are lots of people who agree with me who aren't ideological in the same way that I am. I'm proud to be ideological when it comes to arguing with you, Minister, on this issue.
Sure.
I'm proud to have a different set of ideology which says the state should look after women properly instead of outsourcing their health. Now, despite that, do not put words in my mouth. I am not trying to reinvent science that I don't understand, but I do understand the difference between false negatives and false positives. I've gone to the trouble to understand it. That is not what I'm getting at. I'm getting at the irresponsibility of this state to continue outsourcing cervical check to laboratories in America that weren't up to scratch.
We need to speak to the amendment rather than to the,
yeah, but
to the
he was
wider
speaking to
issue.
the amendment when he said something that I have to fundamentally disagree with.
I'm now going to move to Deputy O'Reilly and Deputy Kelly.
Chair, mine was only a very practical intervention, and as much as the Minister has indicated he's going to liaise with the deputies that put forward those amendments, but I just ask that that would be shared with us in a timely manner to give those of us who will be voting an opportunity. But just for the record, my intention would be to support those amendments in as much as I think you've accepted the spirit of them, and the hope is then that you will come back with something that will be of reassurance to those of us who would seek to support them. Nobody wants to stand in the way of this, but equally time is going to be very tight for us because report stage will be next week. So just in that vein, nobody wants to be looking at stuff at the very last minute and running in and trying to make a decision. We want to get this right. And references to previous tribunals, and they didn't get it right, and part of that was because they were rushed. And some of us have expressed a view that this might be a little bit rushed. But in order to do it right, we need a full set of information before we go into to vote at report stage. So it was only a procedural thing.
Thank you, Deputy O'Reilly. Deputy Kelly and then Deputy Donnelly.
I'll stick to the amendment. I was very much taken by what you said there at the end. 95% of it I agree with. But
that's progress.
There's 5% of it there from the last report that proves that what you just said isn't exactly accurate. But anyway, I'll come to that another day.
Yeah.
Because same thing I'm chasing all the time with you. So anyway, the issue of what you're proposing about dealing with this through instigation rules and procedures, etc., that is not the same thing.
Okay.
Now, if it was, and it was going to deal with the issues that I have raised and the Deputy Smith has raised, I would work with you on it, because I've worked with you on everything to do with this. But what your proceed would be doing is letting the tribunal in some format, or telling them, or asking them, sorry, to deal with this, whereby they would measure, and I'm trying to pick my words properly, they would try to measure the instances where there was a likelihood of cancer coming back and compensating women for that. That's impossible. That is absolutely impossible. Right? So I think, and I'm working with you 100% on this, as I've shown you over a long period of time, but I can't support that, because that's impossible. In fact, I don't even think it's a good idea. Right? So what I have taken from you is in relation to the time period. Right? I have reflected on that, and I have listened to you on that. Now, coming back and having a chat with us about going down the area of telling the tribunal in the rules and procedures to deal with this matter is a completely different thing. It's a bad idea, and I will not support it. Coming back with an amended version of my amendment, sticking in a time period from the time that each woman is told of the outcome, is something I will support, as long as the time period is, what we spoke about earlier, science has shown 5 years, etc. Because I get your point in relation to that. But unless you have that amendment in, Minister, I will be pushing this amendment at report stage. And I believe it should be supported. And I believe it will be supported, hopefully. Because logically, any fair-minded representative can see that there is an issue here. It's how we word it. I accept that. So I would strongly urge you to work with us and come up with an amendment rather than anything else. Thank you.
Deputy Kelly, thank you. Deputy Donnelly.
Thanks, Chair. could I just ask two clarifying questions in trying to understand whether to support it or not? My reading of the section essentially says the rules of the High Court shall apply. So the first question I have is it the case that I have no idea what the answer is it the case that the High Court now, that a judge can say, I'm awarding you X amount for now, and I am putting a provisional sum in case adverse events happen in the future? So I guess if the rules of the High Court are being applied, could the High Court essentially do this now? Is the first question. The second question, to your point on, if we do something like this, do we have to have a perpetual tribunal so that you could come back to the tribunal to say, right, we're X number of years on, I've had a reoccurrence of cervical cancer, I believe this is linked to the first one, and I would like the tribunal to judge on that and therefore award me if they believe there is a link. Would it not be possible to refer such future judgments just back to the High Court, right? So if I guess if it is the case that the High Court can already make such provisional judgments, then my reading of the power of the tribunal is that it could do so as well. But we'd need something in to say, and by the way, if such a future judgment is needed, it's not going to happen here at the tribunal because we're not just going to leave it open forever, but that such a judgment would be made in the High Court.
So there may be something in Deputy Donnelly's second point that I could reflect on and certainly seek clarity on. Sounds pretty sensible to me, so that's something we can certainly reflect on. I think usefully reflect on in advance of report stage. On the first point, my understanding of the rules of the High Court now is not that they kind of make a provisional award and another, but that they can, in making the award, factor in risk of recurrence and your health into the future. So that's what the High Court does now. No, it can't.
Which is what you are seeking.
Yes.
Yeah. Okay.
But no.
In the High Court.
But nor, as much as Deputy Kelly, who I rarely disagree with, as much as Deputy Kelly thinks that what I'm proposing is difficult to do or maybe not worth doing, I equally think, back to Deputy O'Connell and Deputy Durkan's point, to actually establish if somebody gets cancer 5 or 10 or 15 years later, whether that is linked back to a smear test and an audit many years ago is also not necessarily the case either, as you will understand, Deputy Dr. Harty, better than any of us. So I mean, there can be obviously interval cancers, there can be cancers that come back with, you can develop cancer later in life that has no link whatsoever back. So it's not as, and again, you're not suggesting this, but for those watching it, it's not as simple as saying, I have cervical cancer now, I had a discordance 10 years ago, therefore this must be arising from that.
Could I just ask one clarifying question just on that?
Yeah.
Right. So is it the case, again, I don't know what the situation is, but with the High Court says, look, where I'm awarding you X amount based on current observable damages to date, and maybe I'm adding in a risk-adjusted amount for a reoccurrence. To Deputy Smith's point on signing a waiver, I didn't read anything on signing a waiver, but is it implicit then in accepting a judgment that you are saying, by the way, if I do have a reoccurrence of cancer in 3 years' time, I'm not able to come back to court and say, it's up for the court to decide, but my case is there is a link, and I am coming to court to prove that there is a link. Do you lose the ability to do that in a few years' time once you accept an award?
We think that may be legally possible. Now, whether it would be successful or the likes is a matter for the court.
That's for the courts to decide. But you could come back, you think?
It's my understanding that it could be
you don't
a
have
new
to sign.
case.
Yes, you don't have to sign away your rights to coming back in the future.
On a new case.
I tried to amend it.
And in fairness, Deputy Smith raised this in the Dáil on cervical check statements, and I know what she was, and I get the point, I suppose.
But I put in an amendment as well.
Oh, sorry, you did, yeah, absolutely. But it's a case of whether it's seen as a new case by the High Court. So look, I think rather than accidentally adding to the confusion here, I mean, I think I can usefully seek clarification for committee members in relation to what the situation Deputy Donnelly has illustrated well. That is something actually if something comes back, can you go to the High Court on that matter? I think that's a useful point. We can find clarity on. It seems logical as well. And just from a procedural point of view, taking Deputy O'Reilly's point, I mean, what I would suggest we do is perhaps as soon as, maybe the clerk can help me, when will the deadline for amendments for report stage be?
Thursday.
Tomorrow?
Or Friday, maybe.
Yeah, I was presuming it might be Friday, and I was going to suggest that we could usefully schedule a meeting for members of this committee with my officials tomorrow, to tease further through these sort of issues.
Deputy
Just on that,
O'Connell.
we're focusing, just trying to be helpful. We're focusing on the reoccurrence of cancer here. What if somebody is in this group that hasn't tried to have a family yet, and they have stage 1 or whatever, and then they decide to have a family? Like we're saying the worst, not the worst, but the only bad thing that can happen is a recurrence of cancer, where you mightn't be able to have children, or there could be difficulties with births and stuff due to the cervix been damaged. So I think if we're going to amend this and allow further, I suppose, reopening of it in the High Court or wherever, it's not really just cancer we're looking at. It has to be all sorts of things that could arise, and I think that's really hard to quantify. I just think it's more than cancer we have to look at here.
Yeah, and I mean, I just make the point. I mean,
I'm just making the point.
My final contribution on these amendments is that the rules of the High Court apply here in relation to this. What we're trying to find is a better pathway than going to the High Court. Judge Meenan outlines how he believes this is better: heard in private, written statements, experts available to the judges, case management protocols and the likes. But we are still applying the fundamental rules of law that would apply in the High Court. So these are issues that our High Court grapples with today on a daily basis. And you're right in taking in the whole impact of a wrongdoing on a person.
Thank you, Minister. So can we now come back to the amendments then? Amendment number 11, Deputy Kelly, are you moving that amendment?
I know I move and withdraw on the basis that the Minister will reflect on what I said, but I strongly say to the Minister that before Friday I would encourage you to draft your own amendment to this. Otherwise this amendment will be pushed and I will be asking for the support of the Houses.
Thank you. And Deputy Donnelly, in Amendment 12, do you move?
I move, Chair. Yeah, thank you.
And
right, so we're moving on to a separate issue than the one we've just been talking about. Minister,
your amendment is 14.
Okay.
Yeah, sorry. Sorry, Deputy Donnelly. Yeah.
Thanks, Chair. So, Minister, the purpose here is to try and provide protection to women as they're being cross-examined. So, a lot of the genesis for this tribunal was a very real concern for the trauma that the women were going through in the High Court. And the Taoiseach promised, no women would have to go to court again. I think there was very strong public opinion as to, in some cases, how the women were being treated. Now, maybe I'm being unfair, but my understanding, I didn't see any of the proceedings in court, so I'm only going on reports, but my understanding is women were being asked very personal questions about their sex life in the past. I can only assume almost in a sort of victim shaming the line of questioning, because if you're asking a woman who has cervical cancer about her sex life, presumably the implication is, that it's partly her fault. And I think the public reaction to that was very strong, and I think the reaction in the Oireachtas was very strong, to say women should not necessarily be subjected to this kind of questioning. And so one of the things the tribunal achieves is that it brings it into private session, so that at least women who want to use the tribunal, who don't want to answer these kind of questions in public, can now do so in private. But the second part is the actual process of questioning itself. Now, my understanding is that in the High Court, as things stand, a judge can make an award for aggravated damages based on how a witness is cross-examined. And so a judge might find in favour of the woman or in favour of whoever the person being cross-examined is, and say, you know, I believe there is negligence, I'm awarding X amount of money, and on top of that I'm also giving a second award based on how you have treated the witness under cross-examination. And so why bother restating to an extent a power that's already there? Really to underscore the point, one of the core principles of this tribunal, which is that, I mean, negligence is being established, and so the labs and indeed the state have the right to defend themselves. Of course they do. But by restating clearly, as opposed to just saying the rules of the High Court apply, and that's all the following rules, by actually making a point of referencing aggravated damages for unnecessarily aggressive stroke adversarial cross-examination, it's making a point in the legislation that says, yes, you may cross-examine, you have the right to defend yourself in a case of negligence, but be very aware that front and centre in the tribunal's mind is the treatment of these women. And so that's why it's there, rather than just accepting that it's part of the normal powers that a High Court judge has. Why state it explicitly? For that reason, because the tribunal by definition achieves one of the aims, which is to move from public to private session. I believe that another core aim is to provide a respectful way. It can still be robust, but a respectful way of you know, making these cases. So that's why it's there.
I fully agree with the substance of what Deputy Donnelly is trying to do here. I think it's something we all want to do. And obviously I would differentiate between the state's legal representatives and the legal representatives of laboratories and the likes in terms of questioning and cross-examining and some of the issues Deputy Donnelly referred to there. So I have looked at this already and I've taken some advice on it. And I've also seen some court cases and court rulings where aggravated damages have been awarded based on the conduct of the wrongdoer or his or her representative in the defence of the claim of the wronged plaintiff. This is a place that I can see why the deputy wants to have it explicitly stated. Respecting the independence of the tribunal, my sense is the rules and procedures, something that everybody can view, may be that place. I have liaised with the tribunal to ensure that they're satisfied that they have this power, and they do. What I'd like to do is just explore it a little further with the deputy between now and report session tomorrow, in relation to sharing with you some of the information I've been given by the tribunal, in relation to assuring you that they have the power, but also addressing the fair points that the deputy makes in terms of, is there a way of visibly showing that? I'd suggest women going to the tribunal and are unlikely to, we're all unlikely to be reading the legislation, but perhaps more likely to be reading the rules and procedures of the tribunal. But let's maybe have that discussion and see if we can find a way forward. I could get into the technicalities and the wording of this amendment, but that's not the point for today. There's some problematic issues in relation to the wording, but that's not for today, because I know what you're trying to do, and I don't disagree with what you're trying to do. It's just a question of how best and most appropriate to do it. But I do want to provide an assurance to the committee and to the House that through our linkages with the Attorney General's office and the tribunal itself, they are satisfied that they do have the powers to do what the deputy rightly wants them to be able to do in terms of aggravated damages.
Thanks for that, Minister. Thank you. Just on a point of clarification, I guess my intention or assumption is not that the women would necessarily read it, but that the lawyers acting on behalf of the labs will most certainly read it. It's a message to the lawyers rather than a message, I think, to the women. If you're satisfied that the power is most definitely there, the conversations have been had, I accept that. I would certainly welcome if there is a document on rules and behaviours and all of that. I think it would be very important to have that in there. So. Chair, I'm happy to move and withdraw the amendment.
Thank you very much. In relation to Amendment 14, Deputy Smith? Okay. So, Amendment 11 has been moved and withdrawn. Deputy Donnelly, are you moving Amendment 12? Moved and withdrawn?
I think I did, yeah.
Thank you. And Deputy Smith, in relation to Amendment 14, move?
Yes.
The question is that the amendment be made.
I can't vote, Chair, I can't.
Are you calling a vote?
No. That's it, why you asked the question.
Oh, sorry. The question that the amendment be made.
Look, say on amendment 14.
Sorry, they can't. Sorry, they can't. No,
They can't.
My mistake.
Yeah.
Can't call vote. Yeah. So,
Both.
I'll deal with the version that reports that.
okay, so
That's fine. So are you withdrawing?
If I withdraw, I can reinsert it, can I?
Yeah.
Yes.
Yeah.
Okay, move and withdraw.
thank you. So the question is then that Section 17 stand part of the bill. Is that agreed?
Agreed.
That Section 18 stand part of the bill. Is that agreed?
Agreed.
That Section 19 stand part of the bill. Is that agreed?
Will, I just want to speak to the section. I'm not challenging the section.
Section 19. There's an. There is no amendment, but you want to speak to the section.
Yeah, so I have an
Yes.
amendment in that's out of order. So rather than speak to the amendment, I'll speak to the section.
Excuse me. Sorry. Yes. Yeah.
You're
yeah,
okay?
Sorry, yes.
Great,
Yeah.
thanks. So section 19, Minister, is on costs. The amendment was ruled out because it is a charge in the state, which in fairness, I guess, in this case, it would be. And really, what I would like to make sure in section 19 on costs is that cost is not a barrier to any woman or family who want access. I know some of the legal teams are operating on a sort of no award, no fee basis, but that may not always be the case, and the volume of cases is likely to go up considerably. And so what I had tabled was an amendment that would amend the Civil Legal Aid Act, the 95 Act, and very simply include in the appropriate section participants in this particular tribunal. So that's all it was seeking to do. So I'm very open to. Well, I'd like to know if you agree with the principle, and then secondly, what the mechanism is. And I'd just like to add the following, which is, I think it would be reasonable that legal costs are covered where they are a barrier to a woman or her family accessing the tribunal, but critically that the right level of legal representation would be covered. So, we've sat in courtrooms where defendants have gone in and the legal aid barrister has stood up and searched out their client for the first time and consulted for about 10 seconds and then turned around to the judge and defended their client. That's not the sort of free legal aid we're talking about in this case, obviously. This requires solicitors, it may require senior counsel, junior counsel. It's whatever the level of legal representation is that it is appropriate to these women having proper legal teams and legal cases made, not sort of reaching into a pool of junior solicitors and barristers who come in and do their best.
Thank you, Deputy. Deputy Kelly?
Yes. Again, I had an amendment ruled out. It's more or less, it's in the same spirit as Deputy Donnelly. Although I have to say, I think Deputy Donnelly's amendment is a very good amendment. Kind of thinking outside the box amendment, a way of dealing with this issue. But I would be concerned that it's not just about legal aid as we perceive it from listening to Joe Duffy or somebody like that. This isn't the same thing, right? My amendment, which was ruled out because of the cost in the state, basically is to say that there should be no doubt about costs, and costs and worry about costs cannot be a barrier. Cannot be a barrier, or perceived as a barrier, for women to come before the tribunal. Now, neither I nor Deputy Donnelly or anyone else on this side of the House, on the opposite side, can actually put forward an amendment that is going to have a cost in the state. But I do believe, Minister, in the spirit of this, I believe that some combination, and I'm not too hung up about what way you do it, but some combination of amendment needs to be brought forward by yourself to bring certainty to this issue. because otherwise, again, like we spoke about earlier on, anything that would be perceived as being a barrier to stop women to go through here in the first place is a negative issue, and this is a negative issue. The way it's worded, it needs to be revised. So I'd like you to bring forward an amendment. Thank you.
Deputy Kelly, thank you. Deputy O'Reilly.
In the same way, when we discussed this previously, I had indicated where my concerns were, and this was one of them. I also said that on the basis that I didn't want to get into, I'm going to put an amendment. It's not about winning in terms of chalking up amendments. It's about getting this right. So access has to be key, and anything that acts as a barrier to access. Now look, we all know that if you want to ensure that something goes on for a very long time and costs a lot of money, you know, the more lawyers you involve, more in all likelihood, the higher the cost. But you have to balance that against the need that women will have for that advice, because while we might regard it as a non-adversarial process, it certainly won't be for them. It will be extremely traumatising, I think, for a lot of people. They're going to have to go back over a very traumatic time in their life and do it in an environment with people who are legally trained, and to go into that arena without sufficient advice, support and or representation as required. So, I mean, the amendments have been ruled out of order, but I would hope that the Minister understands the spirit of those amendments and will, as has been said, and I would have said it in my own remarks, come back with, I'm disappointed that there's not an amendment to cover this, but come back to us with an amendment, bearing in mind, as I have said, the time is extremely tight. But I think that the view, and I don't think there's anyone in the room that would object to women getting access to this. That's what we want. But there are barriers there. They have to be acknowledged, and they have to be addressed.
Deputy O'Connell.
The people at the centre of this are the women, and we have to be on the side of the women. And we don't want a situation where labs have extensive legal teams with no cost issue, a David versus Goliath style situation where women who've already been through an awful lot and very, very personal stuff to be discussed, that they would be met with a wall of very experienced legal people, and they're not able to compete as such to have their case. So I just would like to make sure that our focus being the women and the least adversarial process possible, that there's no barrier in terms of that there will be an inequality there when it comes to legal representation. Thank you.
Thank you, Deputy O'Connell. Deputy Durkan.
There, Mr. Chairman. Yeah, I think that the question of that the amendments preferred to Deputy Alan Kelly that they would cast a cost on the state, that there would be liability to the state. There's also liability on various other private entities, like laboratories, that have defended cases already. So there is obviously a case to be answered there. Otherwise, they wouldn't have been dealt with in court. And I don't think that our job would be to defend them or to deflect attention away from them, because I think it's outside of our remit. I think that that needs a bit of careful examination, I would have thought, and recognising also that, as Deputy O'Connell has said, the patients are the people that we have to think first about, and the manner in which the particular individual cases were dealt with, and the degree to which we can in some way alleviate the trauma that was caused for them in very many of the cases, which was very serious.
Minister.
Thanks, Chairman. Just to balance my partisan persuasions, I think Deputy Donnelly made the key point in relation to this round of exchanges. We need to address this. And I think Deputy Donnelly's amendment, Deputy Kelly has acknowledged in terms of the amendment, I think Deputy Donnelly's amendment goes a long way towards that. So what I would propose to do, I have two options basically available to achieve what I think is the same aim. Option one is that I come back, and it's my preferred option, is that I come back with a version of Deputy Donnelly's amendment. It will be a version, the words shall versus may, and I have to get legal advice on this, but that I would bring forward an amendment ultimately trying to do the same thing that Deputy Donnelly's amendment does. The second thing, just to inform the committee, is that it is already legally possible to add the tribunal to a list of prescribed bodies for access to legal advice through a ministerial order made by the Minister for Justice. So the Minister for Justice of the day already has the power to say certain prescribed bodies have access to legal advice. So that's another avenue. Maybe a case of doing both, and maybe a case of doing one of them. My preference, as of now at committee stage, is to bring forward a version of this amendment at report stage. That's my intention. Unless in the next 24 hours I can come up with a compelling reason as to why the other is a better option. But the ultimate aim is to achieve the same thing. So to thank the deputies, and I'll come back at report stage.
The question then is that section 19 stand part of the bill. Is that agreed?
Agreed.
In relation to section 20, there is one amendment, Amendment 17, in the name of Deputy Breed Smith.
Yeah, I think the reason I wanted to put this in was that I guess the Minister might intend the same thing, but just to be absolutely sure that no hearing is conducted in public without the express wishes of the claimant. I know it would fly in the face of everything that you'd stand for, but should we put in stronger wording there to make sure that there is no public hearing without the express consent of the person involved?
Yeah, Deputy Smith and I want the same thing in relation to this. The legislation as currently drafted, it says where a claimant requests the tribunal to hold a hearing or part of a hearing in public and the tribunal agrees that it would be appropriate to do so, the tribunal shall conduct the hearing or part of the hearing concerned in public. I think what the deputy is understandably asking me is that strong enough, or do we need to be stronger? The whole idea here is that a woman, if she chooses, can have her hearing and her personal health and life story heard in private rather than in public. Or indeed the woman can opt to have part of it. She might say, look, I want some of this told publicly, but I'd like some of it, maybe the more personal private stuff told privately. My understanding is that that's, and my legal advice is that the legislation deals with that, allows for it. I have checked with the tribunal that that's their understanding, but I am going to take the day to reflect further on what Deputy Smith has said, because it's absolutely the intention of the legislation, and I think it's fair to say the intention of the Oireachtas, that if a woman does not want a hearing in public or a part of a hearing in public, it should not be in public. And I'm just going to revert to the tribunal and the Attorney General's office. If there's a need to strengthen the language at report stage, I will do it, because I think we all want to achieve the same thing here.
Deputy O'Reilly.
Am I correct in saying that the hearing will be in public if that's what the woman wants? The tribunal won't be able to exercise a veto and insist that certain, maybe I'm phrasing this the wrong way.
Right.
Is there evidence that will be given at the tribunal for which the tribunal will insist that it is private, even in the scenario where the woman might want it in public? Or
Yeah, so the default position is the hearing, all of them take place in private, unless the woman herself says, I'd like this to be in public, or I'd like part of this to be in public.
Okay.
And that the tribunal does need to agree to that bit. So the tribunal needs to agree that it's appropriate for the public bit. But there's no part where the tribunal can say, we're having this in public.
No, but my concern is the opposite way around. So a woman may want, and I have to tell you, given what they're going to be talking about, I suspect that this number will be small, if any, but where she may wish to have it in public and the tribunal says no, is there some form of adjudication for that? Because
Yeah, I can't. This is a bit I'm going to say clarity on, because I can't see how that'll happen, because the default position of our judiciary and our courts is always that they hold things in public. So judges are used to holding things in public. So I can't imagine such a situation, but we're right to probe it. So let me come back to you on report stage in relation to that. If there's a need to tighten up the language, we will. I don't believe there is. Yeah. But Deputy Smith's amendment, it does a different thing.
Oh no, I know.
It's
The woman's consent.
Yeah. So it definitely won't happen without the woman's consent that it'll be held in public.
But is that wording robust enough?
For that, it is. In my view, the question that Deputy O'Reilly asks is the reverse. If the woman's actually saying, well, hang on, I do want this bit in public, is the wording robust enough for that? I need to check.
And it would only be around if there is some sort of appeal mechanism or how it is determined. Look, I'd be straight with you. I don't envisage that there's going to be very many in this scenario, but it is a concern that was raised with me, and you know, we're talking about it, we know what we're talking about here, right? We know what was done to these women, so it's a question of saying if they have that as their choice, then nobody should exercise a veto over that unless they're.
Well, let me check both positions with the tribunal
Thank you.
And reverse.
Thank you.
Okay. So, Deputy Smith, are you moving and withdrawing?
Yeah.
Okay.
Based on what the Minister comes back with.
Thank you. The question then is that section 20 stand part of the bill?
Agreed.
That section 21 stand part of the bill?
Agreed.
That Section 22 stand part of the bill.
Agreed.
That Section 23 stand part of the bill.
Agreed.
That Section 24 stand part of the bill.
Agreed.
That Section 25 stand part of the bill.
Agreed.
That Section 26 stand part of the bill. In relation to Section 27, there is one amendment, amendment number 18, in the name of the Minister. Minister.
A technical or small amendment coming from my engagement with the tribunal, that this amendment clarifies that partial appeals can be heard. The wording was a bit ambiguous previously. So I move.
The question then is that this amendment be made? Is that agreed? The question then is that Section 27 as amended stand part of the bill. Is that agreed? That Section 28 stand part of the bill. That Section 29 stand part of the
Sorry,
bill.
I have an amendment in section 28.
Sorry, Deputy. In relation to Section 28, Deputy Kelly has amendment number 19. Sorry.
Yeah, this is just a clarification, Minister, and maybe it's just the eye working again. But, you know, as currently drafted, where a party accepts an award is not rejected by the parties, it's then referred to the High Court for the appropriate order to be made. But as it's currently written, it stands that even the rejection of a tribunal award has to go to the High Court. Now, why is it drafted in such a way?
Yeah, so this is one that I have asked the Attorney General to come back to me on before report stage, and I will provide clarity to Deputy Kelly.
Because I think it's just odd. Firstly, it's not necessary, but secondly, it looks like it's just a drafting error.
So your argument, this was one that I was looking for the opportunity to get your input on. Your argument is that you should only have to go to the High Court. You should not be necessary to go there if the tribunal cannot assist.
Yeah, if it's rejected, yeah.
We've asked the attorney to interpret your amendment, and I'll bring that back for our report stage. Thank you.
Common sense, really, I think.
I think so.
Move and withdraw.
Yeah.
The question then is that Section 28 stand part of the bill.
Agreed.
That Section 29 stand part of the bill.
Agreed.
That Section 30 stand part of the bill. That Section 31 stand part of the bill.
Agreed.
Section 32 stand part of the bill.
Agreed.
That Section 33 stand part of the bill. That Section 34 stand part of the bill. That Section 35 stand part of the bill. That Question 36 stand part of the bill. That Section 37 stand part of the bill. That Section 38 stand part of the bill. In relation to Section 39, there is one amendment, Amendment 20, in the name of the Minister.
This is simply an amendment that's drafted following consultation with the Data Protection Commission, and this is the council we've engaged to work with the tribunal on the drafting of rules in relation to data protection.
Any other?
I move.
Okay, that question then is that Section 39 as amended stand part of the bill.
Agreed.
And finally, that Section 40 stand part of the bill.
Agreed.
Yes.
One quick question for the Minister. Minister, obviously the bill requires the voluntary cooperation of all parties, the women, their families and the labs and the state. Presumably we have the state on board. The indication is that the women affected are satisfied with the parameters, notwithstanding some of the debate here today. Have the labs indicated yet whether or not they are going to cooperate with the legislation as drafted?
The answer is I don't have a definitive answer to that. I know that the labs were engaged with as part of the process in terms of engaged by Judge Meenan. So the content of this legislation won't be a surprise to any of the parties. But I think until this actually gets up and running, I think it's going to be hard to tell. Once we pass the legislation through the Oireachtas, I think then will be the appropriate time to further engage with the labs. But I would encourage, of course I would encourage all parties to avail of this as an alternative to court as well, but I haven't had any formal engagement in relation to that. But I'm just checking, we're going to check in further. Sorry, I'm advised by my officials that we will check in further with the laboratories later this week in terms of their viewpoint so far.
None of them have said that they're not willing. None of them have opted out at this stage.
Not that I'm aware aware of, no. And as I say, all of them, to the best of my knowledge, had an opportunity to input with Judge Meenan in terms of giving their views on what alternatives were, and the judge obviously took all of that into consideration.
Okay, thank you.
Can I ask you a question for you on that? Was an interesting answer. If we pass this legislation and the labs decide they don't want to opt in, how does that, where stands the legislation?
Yeah, I think, and I'm no spokesperson for the labs, I think this is some of the important points I've been making in relation to aligning the tribunal with the rules of the High Court. I think greatly makes it likely that all parties will participate because the legal rules are the same. The format might be different, the protocols are different, the compassionate way we engage, as we've been discussing with some of the amendments, is different, but the legal rules are the same. It is absolutely true, though, Deputy Smith, that it's a voluntary process, and that a woman in some cases could decide not to go there. I don't want to go there, I want to go to the High Court, as is my constitutional right, and laboratories can as well. And we've been grappling with this, as you know now, for many months. There is no legal avenue that I can find in terms of an adjudicative tribunal where you can remove, or indeed would wish to remove, the right of someone to go to the High Court.
Thank you.
One thing on the bill.
Yes.
Deputy.
Sorry, Deputy O'Connell.
Deputy Smith's question. Is there a position where the labs could turn up for the tribunal, let's say for my hearing, but not Breed's hearing? Can they be a la carte with their client? So let's say if it suits Lab A to turn up for my hearing, just using yourself, Breed, as another example, and then they go, actually, no, we don't want anything to do with that particular.
Yes,
so can they pick and choose, so they turn up for whatever
they can,
client, if that's the word?
They can, and different women can make different decisions as well.
Well, the women's different.
Absolutely,
Yeah.
I'm very well aware of that. But each case is different as well.
So it's an individual case.
And in each individual case, so yeah, we're not legislating here to say this is how all cases will be dealt with, nor are we asking the labs or support groups or patient advocates to sign up that everyone goes this route. It'll be individual cases.
And
There's a difference. The patient's request to be dealt with by the tribunal, surely there should be compunction, as there would be on the HSE, on the labs to meet that request from that woman, rather than the other way around.
Yeah,
because they're implicated.
Yeah, and in the very lengthy time, and remember, these are not ideas that I've come up with. We brought in some of the most learned minds and a judge who specialises in clinical negligence, Mr. Justice Charles Meenan, to come up with a model. There doesn't seem to be any legal avenue available to compel external agencies to attend, and that's it's not welcome news, but it's the truth. That we can't make people. So if this was again a matter of just the state, very different case. But the fact that it's a matter of the labs, I don't have the legal authority, nor does Oireachtas, to make the labs attend.
in terms of compatibility, if they're outside the jurisdiction, there are limitations there.
Yeah, and people have the right. People have the right.
And then in terms of where we go forward,
you can't trump our court system and its place in our constitution.
if Lab A just decides that they'll turn up for my hearing and they won't turn up for the second person's hearing, and they're a lab that has a contract still in existence and perhaps we've got extra capacity from them, how does that stand in terms of our dealing with them as a company?
Yeah, I suppose that's the question. That's an ethical question we've been grappling with, and I've been grappling with. But you got to remember, and I know you do, as a great supporter of our screening programme. I mean, priority number one for me, as Health Minister, had to be the continuance of screening. And Deputy Smith might, I hope she believes me on this, it would have been great to be in a position to have the capacity here in our own country. As Dr. Scally has noted in both his reports, and I'm sure will note when he comes before this committee, there wasn't another option in terms of keeping our screening programme going. Currently.
Deputy Kelly.
Two very quick ones. Firstly, Minister, Judge Mary Irvine, has there been a decision made, because I understand there has, but I want you to confirm, has there been a decision made not to host this tribunal until after the Morrissey judgment appeal outcome has been delivered? And can we confirm that? Because I've asked it loads of times and I've been told it's happening. Now for me, we won't reopen the debate, but I think it's important that you confirm. Second issue, about compatibility. In relation to some of the more complex cases, there may be a requirement for members of the HSE to be witnesses at hearings. Is it your intention to require state employees such as the HSE to attend the tribunal.
The second one first, absolutely, 100%. Anybody who works for this state and works for our health service will be expected to cooperate fully.
Okay.
That'll be an expectation that I know is not just mine. In fairness to the Director General and now the CEO of the HSE, I know it's one he'd share as well. In relation to your first question, it is a matter for the tribunal to decide when to commence its hearings. My understanding is that your position, your information is correct, but I'd like to confirm that in a more formal way. I'd also like not to say anything on the floor of the Oireachtas that would second guess our courts and their decision to either but it's important because there'll be people here thinking it is important, and I'll tell you why it's important. Because it's important as to whether our courts decide to hear an appeal, which is a matter for them, and secondly as to when they do decide to hear it, and do they decide to hear it quickly. So it may not, I'm not suggesting you're doing this, but again, for people watching in, I wouldn't like it to be interpreted as a delay in the establishment of the tribunal, because that may not be the case.
The purpose of the question was seeking clarity, because lots of people are asking me.
No, and I'm happy to provide that.
Thank you.
Thank you.
Just, Minister, before we conclude, if there are two laboratories involved in a case, if there are two laboratories involved in a case, and one laboratory is willing to come to the tribunal and the other isn't, what's the situation?
It'll be a matter for the tribunal to determine whether they can proceed or not, depending on the individual case.
Okay, so the tribunal would make that decision. Okay. So in relation to the title of the bill, that this be the title of the bill, an act to provide for the implementation of the report on an alternative system of dealing with claims arising from cervical check in respect of the hearing and determination outside of the court process of claims arising from acts or omissions arising from cervical check, and for those purposes to make provision for the establishment of a body to be known in the Irish language as An Bíonse Cervical Check, or in the English language as the Cervical Check Tribunal. To make provision for the tribunal, with the consent of the parties concerned, to hear and determine a certain limited number of claims made to it outside of the court process. To provide that a determination of the tribunal shall be subject to confirmation by the High Court and subject to a right of appeal to the High Court. To make provision in the public interest of restoring trust in cervical check for the making available of certain persons of facilities for the purpose of documenting experiences, facilitating discussion and providing information to such persons in respect of cervical check, and to provide for related matters. Is that agreed?
Agreed.
No.
Again, I missed one.
I don't think I could. As consideration of the bill has now been completed, in accordance with Standing Order 87, the following message will be sent to the Clerk of the Dáil. The Select Committee of Health has completed its consideration of the Cervical Check Tribunal Bill 2019 and has made amendments to that bill. Is that agreed?
Agreed.
Minister and your officials, I'd like to thank you very much for your time this morning in taking this bill. The Select Committee is now adjourned sine die.
Thank you.